Thank you very much. It was a great privilege and pleasure to be invited, and I'm delighted to be here. And I'm going to talk today about compensation for breach of the GDPR. If I can make this thing, how do I make it move? Yes, okay. So this comes as a little surprise to the audience. The Nordic-Baltic region, a digital front-runner declaration in Oslo in April. And the key thing, or one of the key takeaways from that declaration, was the focus on information security and personal data protection, which is the theme of this conference today. And just to talk about two recent data breaches that have been on everybody's lips throughout the course of today's conference. Equifax in the United States, a financial information company, leached even data for 140 million of its customers. And Yahoo, we discover, had at one point 3 billion active user accounts, not necessarily 3 billion active users, but 3 billion active user accounts. And the personal data behind those accounts was hacked by a Latvian hacker who is now one of the FBI's most wanted. So let's assume that you are one of the people whose data has been hacked, whose data has been compromised, and in respect of which you suffer some loss. Now, you can suffer two kinds of loss: financial loss if it's your financial data and somebody is impersonating you, or distress. Non-material loss, the fact that you're really worried that somebody is going to know all of your secrets on your various Yahoo accounts. Right, does anybody, there will be lots of questions and answers. You can't sleep. I know it's the first session after lunch and therefore you might want to sleep, but nevertheless you can't. There will near the end be at least 20 questions. You are warned, but there will be a few before then. What's this? The Swedish government, yes. It was the Swedish government in 2014. I'm sorry, the screen isn't showing me the slides here, so I have to keep looking back. And why am I pulling out these two? Because they had to resign because of the fact that the Swedish government lost a lot of data to rather dodgy people outside the European Union. So the loss of data can happen even in the most secure of circumstances, and the effects can be quite serious and wide-ranging for the data subjects whose data is lost. Now, you're all very, very familiar with and very sick of the General Data Protection Regulation and the timeline on the right-hand side. As you can see, there are more than 350 important articles. What I intend to do for the next 4 days is to work our way through the recitals one by one, then the articles one by one, and then the footnotes one by one. At some point you will die. Okay, not quite so bad. I want to focus on the remedies for breach of the GDPR. And we have heard a lot about fines. At the moment, there are powers on the part of data protection authorities to fine data controllers and data processors for breach. And so the Spanish Data Protection Authority fined Facebook 1.2 million last month. And in Donald Trump terms, there are huge, big league fines coming down the road. The 4% of turnover, fines. That's all you see everywhere. But in fact, there is something potentially a lot more serious from companies' point of view as well. Competition law in the European Union shows us that public enforcement by regulators, in that case, competition authorities, and in our case, data protection authorities, is very important, but it needs to be supplemented by private enforcement, by the right of data subjects and others who are harmed to be able to take actions as well. And so the Commission introduced a directive on damages in the context of competition law, and it has adopted the same strategy in the GDPR. And Article 82 of the GDPR provides for compensation claims for material or non-material damage. That is to say, for damage that you can calculate, which is material damage, and for distress, which is non-material damage. And so that's the full text of Article 82.1. Any person who has suffered material or non-material damage, I'm not going to read it, that's karaoke, and that's for tonight apparently. But the important thing for our purposes is shall have the right to receive compensation. And I want to focus for a few minutes on this idea that the data subject shall have the right to receive compensation. How shall a data subject have the right to receive compensation? Those of you who have flown in the relatively recent past will be aware that Ryanair have had some issues around flights not happening because pilots went on holiday or went to work for the competition. And the Flight Compensation Regulation, Article 5.1c, provides that passengers shall have the right to compensation in accordance with Article 7. And Article 7, passengers shall receive compensation, and there's a scheme. Okay, I'm not going to read it. It makes my head hurt. We'll just tear it up and go away. The important thing is that the right in Article 5 shall have the right to receive compensation. Article 7 sets out how. And people whose flights were cancelled in respect of Ryanair last month will probably be due compensation. The Irish Times, the paper of record in Ireland, are very sober. Most cancellation hit Ryanair passengers are due compensation, says expert. Sadly not me, they didn't ask me. I was very disappointed. And then The Sun, one of our red tops, one of our tabloids. Ryanair, the cancelled flights could end up costing Ryanair millions. Capital, bold. Okay, so you get the idea of what's going to happen there. So how shall an affected passenger have a claim for compensation? Answer, Article 7. Let's go back to 82. How shall a data subject whose rights under the GDPR have been infringed have the right to receive compensation? There's no equivalent of Article 7 from the Flight Compensation Regulation. There is no mechanism by which a plaintiff, a data subject, can seek the compensation. So there are three things that we could do to fill in this particular blank. One of them is to look at the text of Article 82 and look in particular at the shall have, and compare it with the text in the other two primary drafting languages, French and German. And given that there are native French and German speakers in the room, I am not going to inflict my appalling accent in either of those languages on you, but just to focus on the fact that both of those are in the present tense. It's not that they shall have and something has to happen, it is that they have the right. So it's straightforward, they have the right, it's in the present tense, you don't need anything else. How many official EU languages are there? More than 10, yes. Fewer than the number of EU member states, because some member states share. I mean, English is an official EU language, but in Ireland we speak English as well. So there are 24 official languages, and in the 24 languages, 5 use the imperative that is incomplete, and 19 use the present tense. And the 5 that use the imperative, English, Maltese, Spanish, Swedish. Swedish is the only Nordic or Baltic state that has the shall have, and Irish. And I'm not going to inflict that on you either. Think Klingon, and you've got a good idea of what Irish sounds like. But the important thing here is that English was the primary working language. All of the documents in the document file are in English. And then they were translated into French and German, and then from French and German and English into the other 21 languages. But the Court of Justice has told us that where texts are ambiguous, there has to be a uniform interpretation across all of the EU languages. But I'd sum it as the most recent statement of that principle, and probably therefore one way to resolve the ambiguity in the primary text is to go to the other texts and to see that they simply say that a plaintiff should have this claim. The second way is to look at what the European Court of Justice, this is the main chamber of the European Court of Justice. People who have appeared in it tell me that it's very nice. I think that's very ugly, but that's just me. And the Court of Justice has, in a lot of cases, said that where regulations and directives contain compensation clauses, they should be interpreted broadly in the light of the objectives of the particular document and to ensure that the people involved, the people affected, get compensation. So going back to the flight compensation regulation, the Court of Justice has progressively expanded the grounds on which compensation can be awarded and the amount of compensation that can be awarded. So Articles 3 and 7 of the flight compensation regulation, which we've already seen, the court has insisted must be interpreted expansively. There is a bizarre IP regulation on the protection of plant varieties, but it does say that if you have a protected plant variety and somebody else infringes your protection, you have a right to claim damages. And again, in Geisbeck, the court said that this must be interpreted broadly to protect the rights in question and to fully compensate the plaintiff, the person whose rights are infringed. This is a destination that Ryanair doesn't fly to. Because they tend to go to airports that are 60 kilometers away from where they intend to be, although they did fly to the main airport here today, or yesterday, which was really good. But under the package holidays directives, again, there are clauses for compensation, and in Leitner, the court held not only must the clauses be interpreted broadly, but under the first package holidays regulation, it wasn't clear whether a plaintiff should be entitled to damages for non-material loss, that is to say, for pain and suffering, for distress. But in Leitner, they said that the directive had to be interpreted in that way. The Public Procurement Directive, like the Competition Directive, again contains damages clauses for losses by virtue of infringement of the directive. And in Stadt-Graz, the court held that the member states could not impose disproportionate limitations on the right to damages. And finally, the leading case on damages comes from one of the equality directives. Look at how early this is, 1993 in Marshall. The pension age for a retired woman was higher than the pension age for a retired man. So Mrs. Marshall qualified for her pension later than her husband did. And the Court of Justice held A, that was gender-based discrimination, and B, that she was entitled to recover the lost pension from the state. And recital 146, I kind of implied that we would read all of them. We're only going to read one. Recital 146 says that the concept of damages should be broadly interpreted, which comes from Sturgeon, and data subject should receive full and effective compensation. That comes from Marshall. So the Court of Justice will interpret it broadly on the basis of the text of the non-English languages, and the Court of Justice cases currently insist that it is interpreted broadly. The Treaty of Lisbon 2009 gave us the Charter of Fundamental Rights, and Article 47 of the Charter talks about the need for an effective judicial remedy. Article 79 of the General Data Protection Regulation likewise talks about the need for an effective judicial remedy. And in Pushkar just last month, the Court of Justice said that the need for an effective remedy under the Data Protection Directive, and this is language that will carry across to the General Data Protection Regulation, requires that national limitations on data protection rights not be enforced. The third way to ensure that data subjects get their compensation claims is for the national countries, as they're incorporating the regulation, to ensure that there is a compensation claim in the national incorporating legislation. Okay, Fair warning, this is the 20 questions. Literally, there will be 20 questions. So this is a map of the European Union. The green shows where there is currently legislation. The blue shows where there are currently bills. The funny purple shows where there are currently reports. The yellow shows where there is one act but something is pending. And the red, at the moment, there is nothing yet. So let's look at the jurisdictions. There are about 20 of them that have done something. What's this flag? Austria. Okay. Austria has legislation. Okay, we're going to talk about 20 flags. Austria has legislation in which there is a compensation claim. Hungary, yes, next door to Austria. And they have a bill in which there is a compensation claim. Netherlands, yes, and they have a bill in which there is a compensation claim. Poland, and they have a bill in which there are 2 clauses dealing with compensation claims. One simply isn't enough. It's like my diet. I'm on 2 diets. One doesn't give me enough to eat. That was my best line, people. Okay, perhaps it's a good thing that I'm not doing either karaoke or stand-up tonight. Romania, yes, they have a bill in which there is a compensation claim. Slovakia, and they have a bill in which there is a compensation claim. Spain, they have a bill in which there is a compensation claim. Yeah, they're about to leave, but until they're around, while they're around, yes, they have a bill in which there is a compensation claim. So that's 8. They have a report in which there is a compensation claim. Czech Republic believe that their existing rules are sufficient to provide a compensation claim. Ireland, yes. And that TA there is the Irish for yes. And we have a bill in which there is probably a compensation claim. Could be better. And there is a legislative process in which I sincerely hope it will get better. So that gives us 11 countries in which the incorporating legislation provides the compensation claim to give effect to Article 82. France, yes. They have an act at the moment which doesn't contain a compensation claim, but they are also likely to bring in more legislation after Christmas, so we wait and see. Germany, yes. And they have an act which doesn't have a compensation claim. Belgium, they have a bill which doesn't have a compensation claim. Yeah, you have a bill that doesn't have a compensation claim. I think that's a bad thing on your part. Go back to the ministry and tell them they need to amend the bill. I know it's new, but there's plenty of time. Pardon? Oh, yes, Lithuania. Yes, sorry. Different pronunciation. Yes, so that's next door. They also have a bill in which there isn't a compensation claim. Luxembourg, yes, they have a bill in which there isn't a compensation claim. It's nearly over. Slovenia, they have a bill in which there isn't a compensation claim. Denmark have a report. They have about 60 pages on compensation, but they don't in the end say that there ought. It's a 2,000-page report. I haven't read it all. Google Translate wouldn't let me. But the 60 pages on compensation I have, and at the end they didn't say they were going to do a compensation claim. We're very nearly there. Two more. Estonia, they have lots and lots and lots of drafts, but no compensation claim. And Finland, again, they have a report, but no compensation claim. So that's 10. 11 have said, let's have a compensation claim. 10 have said, let's not. I think that to ensure that a plaintiff who has had his or her rights infringed under the data protection regulation properly has the claim for compensation, the national implementing and incorporating legislation should provide for it. The ambiguity in Article 82 is a serious one. And the last thing you want is to have to litigate to the Court of Justice, for the Court of Justice to say all of the things that I said under the first two solutions, to say, you know, let's have, interpret consistently across all of the languages, let's apply all of the cases on compensation. Apart from people like Max Schrems, who likes going to Luxembourg, I can't imagine that most plaintiffs want to start in a local district court and end up in Luxembourg. They just want to get their claim against Ryanair. Several of the jurisdictions think Article 82, several of the 10, these 4 of the 10, that don't have national claims think that Article 82 is directly effective. But I think because of the ambiguity, it will take the Court of Justice to tell us that it is directly effective. And until then, even in these 4 countries which have said, let Article 82 do the job, I think even there, it's not going to be sufficient. So, oh dear, the Czech Republic has disappeared from there. Sorry about that. That should have been in green. Damages in green, no damages in red, blue, nothing yet. So that gives you a sense of where we are. Okay, we're in the National Library, but we're also at a situation where about half of the jurisdictions are going to implement the damages claim in Article 82, and I think the other ones should. What's coming down the track? Well, the countries that we didn't do the show and tell on flags for, sometime between now and 7 months' time, are going to have to make decisions about implementation. If any of you are from any of those countries, go home and tell them implement Article 82 before the 25th of May. And the e-privacy regulation, which was voted on in the Parliament about 2 hours ago, Parliament recommended its adoption. The Article 22 is in the same terms as Article 82 of the GDPR because of the interlinkage of the remedies under the e-privacy regulation and under the GDPR. Thank you very much. Gorif Mahagoyev is the Irish on the bottom. Thank you.
Okay, some questions? Or at least one? Yes.
Okay, I'm just curious in terms of your view on the opportunity to shop for the best place to bring a lawsuit, because I know, for example, perhaps Ireland, I'm assuming, has the right to claim punitive damages, and France doesn't.
Yeah.
And punitive damages might be very, very much worth claiming. For example, if you're a data subject in France and you want to claim for punitive damages against Google based in Ireland, what are the regulations right now saying about that? I'm just curious.
The regulation, the GDPR assumes the general European rules on remedies, which is to say that the remedies go according to the law of the member state. So if you can demonstrate that you have a loss in Ireland, then you can claim in Ireland and you can get all of the remedies that are available in Ireland. But you have to be able to demonstrate that you have suffered a loss in Ireland. So if you're a French data subject, Veltimo, the Court of Justice decision 18 months ago on the Data Protection Directive, pretty much implies that you have to, you can sue in France because that's where the primary loss is. If you go to the if you come to Ireland, other lines of authority say that you have to sue only in respect of the loss in Ireland. So your primary loss is going to be in France. Maybe you should sue there. Your minor loss will be as against Facebook in Dublin, but as you say, you might get punitive damages, but punitives in Ireland are nowhere near as generous as they would be in the US. So really you want to go to California.
Okay, any other question, comment? So maybe I would use the opportunity to ask what do you suggest for Latvia to do, how broad this clause must be, and so. Because we have a general civil code about losses, so we can go to court and ask for losses for anything possible.
Well, you still have to have a cause of action. Before you get a remedy in the losses, you still have to have a cause of action. And Article 82 says that the plaintiff should have a cause of action and in my view, according to national law. So the Latvian bill, last month introduced, should specifically provide for the claim for damages and then allow the national law on the range of remedies to apply. But the General Data Protection Regulation Implementation Bill should specifically provide for Article 82 first.
Yes, and I would like to add that our law now enforce this based on directive has this clause.
Yes,
Yeah.
because the directive in Article 25 requires it, and the Czech Republic says it's not going to change that. So that's one way of doing it, just leaving what's already there rather than repealing it. But something needs to be done so that data subjects properly have remedies. I should add that Article 80 allows for class actions. And now think about it. Let's assume that 150 million Equifax customers get $1 each for damages, and they all sue in the class action. That's $150 million. If they get $100 each, that's $1.5 billion. So the class action claim for compensation will quickly dwarf the fines. I know it's all fines, 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 but in fact, class action plus compensation could be a lot more.
Is it possible that class action is brought by this organization that protects also data subjects? There is a clause about
Yes, there
that,
is.
yes?
The data protection regulation allows quite a broad view of who can bring class actions, and one of them is that a consumer association or other group should be able to bring them. Some jurisdictions are implementing that, most aren't yet, but I think they will ultimately be forced to by the Court of Justice.
Okay, thank you. And I will give you a small present.